Greetings. I am so glad you could join us for our webinar today on file wrapper analysis for intelligent and efficient patent prosecution. And I'm really happy that you're here because I think this is such an important topic. And it's important first because patents are really important. I mean, if you're working with a startup, these can be the difference between a successful and an unsuccessful funding round. There's a new product, it can make the difference between whether it goes into the market on its own or whether it's immediately undercut by copycats. In general, patents can change the difference between something R&D being a profit center versus R&D just being a money stock. So patents are a big deal. But prosecution and file wrapper analysis are also a big deal, almost independently of that importance. And so what I want to do today is I'm going to start by talking about what I'm talking about and then why it's important. So file wrapper analysis is basically the process where we as patent attorneys are able to take the combined knowledge of all of our companions and all of our peers and contemporaries and the people who've gone before us that is captured in the electronic file records from the U.S. Patent Office, and then apply that in our own practices to make our practices better so that we can be more efficient, more intelligent, and just so that we can get the best results for our clients and do the best we can to get protection for our innovations. Now, I've talked about file wrapper analysis to a number of people, and I've heard people say, well, what they're doing now works, they have very good allowance rates, and every invention is different, and really, there's not particularly a big need to change from what they're doing right now. But I think that that's a little bit wrong. And so I want to try and convince you that change is coming. And in fact, if we look, change has already come to many areas of the legal profession. So the standard model, we go from a bespoke hourly billing, and then it moves through as things become more developed, things become more systematized, packaged, eventually things turn into a commodity, much lower price, much higher use of technology, much more application of existing knowledge rather than recreation on a case-by-case basis. And we've seen this in many areas of law already. So that includes electronic discovery, it includes search. Just as an example, so Fenwick and West automated the task of preparing documents that startups would need to file, like articles of incorporation, for example. And this automation reduced the time spent on that from between 20 to 40 hours to 1 to 2 hours. It's a huge change that has come to many areas of the law, and it's going to come to patent prosecution as well. So I like to think outside of the law, right? Everyone's heard of Tesla, and Elon Musk has said that Tesla was really built on the back of consumer electronics because that's where he got all of his battery technology. Patent prosecution is a very knowledge-intensive task. You have to deal with a lot of natural language documents, but the external forces that drive technological change are already making the innovations that are going to be necessary for technology to be applied to patent prosecution in exactly the same way it has in other areas of the law. So for example, the natural language processing is already being developed. Improvements in hardware is driven by the inexorable process of Moore's law and then the ability of new service delivery methods such as SaaS and big data. And so these forces are driving technological change, and this technological change is going to impact patent prosecution regardless of whether it appears that things are working well now or not. And in fact, even if you look at the U.S. Patent Office, we can see the change is even reflected there within that institution. So it wasn't that long ago. I was still practicing before you would file anything electronically. And I remember when we first filed an electronic filing for an office action response. And we made sure we filed it well in advance of the deadline. We weren't going to miss anything. We had our postcard. We were all ready to go. Now, it is almost unheard of for me to file anything in paper. There has to be a really specific reason to do that. And things are continuing in that way. So the Patent Office has an open data initiative where it is progressively making more and more of its information available to the public. and it's released just a new batch of APIs just in this last June, and that includes things like being able to see what kinds of rejections are in office actions, bulk image searching and downloading. So change and the technological progress is already apparent. And in fact, we can also see this in various commercial products. So people have taken this new information and the new technology and the new algorithms for processing it, and they've offered many different tools, some of which can be used for file wrapper analysis, others which can be used for analytics. And I think these are things that attorneys, if they haven't already incorporated them into their practice, they will have to at some point in the future. And as I put up on the next slide, this is actually something that's expected of us as attorneys. We do need to know about technological changes. We need to be able to understand its benefits and risks, and we need to incorporate that as necessary for our clients. And so what we're going to do today is talk about how to do that for file wrapper analysis. And my co-presenter and I, so I am a patent attorney. I've been practicing for over 10 years, generally in the software area. My co-presenter, Julie McConihay, also a patent attorney, well over 10 years experience working primarily in the chemical arts. And we're going to talk about how we have used file wrapper analysis in our own practices to try and take advantage of these changes, take advantage of the newly available information to get the best, most efficient, intelligent results for our clients. Just a brief housekeeping note. So as part of this webinar, you have the ability to ask questions. If you have any kinds of additional information that you're looking for, there is a control panel on the right of your screen. If you ask a question, we'll be notified of that. We can answer that either at the time or at the end of the webinar, depending on the nature of the question and where things are. And so I guess with that, what I will do is hand things over to my co-presenter, Julie McConihay, to talk about file wrapper analysis 101, which would be subject matter eligibility in the context of her practice in a chemical or biotech area. So Julie, I believe the floor and the presentation is yours.
Okay, thank you very much, William, and it's a pleasure to be able to speak with everyone on the line today. For the purposes of our demonstration, let's go ahead and consider an office action that was issued for a published U.S. application that's directed to pig myostatin gene locus and uses thereof. And as you can see, this application had at one time one pending independent claim, which was directed to a DNA terminator, wherein the DNA molecule was selected or consisted of one of these different types of DNA molecules that are characterized by a particular sequence ID number. Well, let's say that I was faced with a 101 rejection from an examiner, and you can actually see the 101 rejection that was issued in reference to this claim here by an examiner GreyB. And let's say that I haven't responded to a 101 rejection for some time, or I've never worked with examiner GreyB before. What I do is let's take a look at the rejection that examiner GreyB made. As you can see right here, she indicates that our claim is not patent eligible subject matter pursuant to 35 U.S.C. 101 because the claim terminator sequence is a naturally occurring sequence. So what I can do if I don't have any prior office action responses that I've written before or any resources that tell me what examiner GreyB likes to see in rebuttal of a 101 rejection, I can turn to our Arguminer software, which is right here, and I can drag and drop the office action that contains the 101 rejection into the software. And once I proceed to the results, and as you can see, I have a screen here that has quite a few different applications listed. And what these applications have in common with the office action that I just uploaded would be any of the rejections that are contained in that office action. Well, what I really care about is how examiner GreyB dealt with 101 rebuttals of her 101 rejections. So what I do is I go up here to step 1, and I indicate that I want to see office action responses that address rejections under 35 U.S.C. 101. I then go down here to step 2 to select parameters that are going to narrow down my results even further. So for instance, the first parameter that I can select is I want to see office action responses that were responses to office actions issued specifically by examiner GreyB. I want to see office action responses that have resulted in a successful rebuttal of a 101 rejection. And then I also want to see office actions that specifically have the verbiage that examiner GreyB used in her 101 rejection. And if you'll recall, that was that my claimed elements were naturally occurring. So once I input that here, I go back up over here to step 3 and I apply my selections. And you'll see that I've got results that are significantly narrowed down. In fact, I have 2 applications that I can take a look at. For the purposes of our demo, let's ignore this one because that's the application that we're actually considering right now. So I go up here to the first application in my results, and I see that it's directed to a neural progenitor cell population that may or may not be relevant to my claims, which recite DNA sequences, but I'm going to go ahead and take a look at the office action response to see what a successful argument looked like for patent eligibility under 101. So I click this button, and what happens is I'm going to see the actual office action response that the applicant submitted. And the first thing that I see here is that the applicant amended the claims, and you can see that they're directed to cell populations. And then I can scroll down and I can take a look at the rebuttal of the 101 rejections that examiner GreyB made. And specifically, I can see that this applicant made 2 arguments. The first was that the cells in the claims differ from those that are their natural equivalents. And then the second argument is that the mixture of cells that is claimed is not naturally occurring. Excuse me. So then I can scroll down and I can take a look at the arguments that the applicant set forth in support of both of these points above. And I can see here with regard to the applicant's argument that the cells are not equivalent to those found in nature, that the applicant has found a third-party journal publication that supports their assertion, and that they talk about that here. Then I can look and I can see that the second argument, that the claims that those mixtures of cells don't occur in nature, I can see how the applicant set forth their argument pretty thoroughly, and that they included references to the relevant case law. And so I think at this point, well, gee, this particular argument, this second argument might be helpful to me, but what I'd like to do is I'd like to see how examiner GreyB responded to both of those arguments. So I go back to my results and I go to this tab here, which says Access Results and Related Documents. And I click on that, and what that is going to do is it's going to pull up the relevant documents from the file wrapper for my consideration. And you can see that it pulled up the office action response that I just talked about. And you can see that examiner GreyB then issued a subsequent non-final rejection of the claims. So I'm going to pull that up here, and I'm going to scroll down, and I'm going to take a look at what examiner GreyB had to say about the applicant's arguments. So here you can see that examiner GreyB withdrew the 101 rejections in light of the amended claims and also in view of applicants' amendments and arguments. So here examiner GreyB talks about how the amendments to the claims were dispositive. And then I scroll down here and I can see that examiner GreyB discusses at length that third-party journal publication that was used as evidence of the fact that the claimed cells in this application are different from the ones that occur in nature. And I do see at the end that examiner GreyB does talk a little bit about the argument that the applicant made about mixtures of cells. And so my take home here is that it seems to me that examiner GreyB might tend to put a little bit more weight on third-party evidentiary references that can be cited in support of a rebuttal of a 101 rejection. But I can also go back to my results. Let's see here. And I can also engage in the same type of exercise by reviewing the file wrapper and the office action response and the examiner's thoughts on those arguments for this application here. I can also, if I think that it would be helpful, change my search so that I'm looking for similar results for the examiner's supervisor, since after all, the examiner may have to defer to her supervisor when it comes time to ultimately withdraw those 101 rejections. So at this point, I am going to turn things back over to William, who has a substantial amount of expertise in dealing with 101 rejections, and particularly in his area of expertise, which is computer software. So let me make that switch right now.
Excellent. Julie, thank you so much. That is, I think, a really good demonstration of the efficiency that you can get by performing file wrapper analysis to see what approaches other people have used, what's the most effective with an examiner, and maybe even being able to take some of those arguments. I noticed that you had a lot of the cases where it was talking about not just the facts, but also the arguments about the mixtures of cells. So I think that's a really good illustration of how you can get efficiency just by looking at what other people have already done. What I've found in my 101 practice is very similar. And what Julie demonstrated is kind of my go-to when I see a 101 rejection. But I found it can often help to take it a step further. So what I've done here is I've uploaded a office action. It had a 101 rejection, and it had the case that was cited against me and used the basis of rejection was one called Electric Power Group, which if you have worked in the software area, you've probably seen that case. And so what I am going to do is I'm not just going to look for, okay, these are things, again, these are responses where people responded to 101 rejections. I'm going to look for responses specifically to other office actions that cited the Electric Power Group case. And I'm also going to look for responses to make sure that those responses themselves also cite the Electric Power Group case. So by taking advantage of the fact that you're going to see the same kinds of citations over and over, or let me rephrase you, patent prosecutors are going to see the same kinds of citations over and over when they are prosecuting patents. We can take advantage of that to really pinpoint and narrow down what we're looking for without losing any of that efficiency that Julie showed us. So I've put the search strings in, and let's just go to this first result and see what we have. So we can see how using this file wrapper analysis gives us the option to benefit from what other people have already done in similar situations with, in this case, the same case. So we'll scroll down, and what we're going to find is this case and this office action does a great deal of talking about Section 101. So we can see they do talk about Electric Power Group that was cited against them also. But beyond just looking at Electric Power Group, this person has done a ton of work laying out the requirements for a 101 rejection, laying out what the limitations of that are, like the claim must be considered as a whole. And all of this is something that I can potentially use and apply in my case without having to go through and reinvent it. Again, building on those efficiencies that Julie demonstrated when she was looking at the 101 in her area. So we've got a lot of case citation. We don't need to read through all of this here, but I just feel it's worth pointing out that there's a lot that was done in this and a lot of effort went into it. And that's a lot of effort that doesn't need to be duplicated. But here we have Electric Power Group. And you can see in this that they talk, again, at some length, describing the case, and then they also talk about how to distinguish that case. And so they explain, here's why it was found eligible there, and here's why the claims in this application should not be treated as ineligible based on Electric Power Group. And the office action goes on. It says these are much closer to the claims in Diamond versus Deere, showing it's more close to something that is eligible rather than something that was found not to be eligible. Ultimately, though, I think what this illustrates is that because there's so much commonality, yes, there's differences. Every invention is different. That is certainly true. But the rules are the same. And the practices, yes, there's variation, but examiners tend to do the same thing. As Julie said, they'll talk to their supervisors. The supervisors will spread knowledge. The knowledge goes out. It's going to be common among the people that they're working with. And we can take advantage of that. We can leverage that using file wrapper analysis to find these arguments and to build tremendous efficiencies, even when we're targeting specific issues like a particular case. And in fact, something else that I found that's very useful is you can even do this when you have the argument you want to do. So I will give you a non-hypothetical example. So I'm not using an actual client data here, but this is analogous to something that actually happened to me with the 101 rejection, which is I said, okay, I look at the rejection and I decided I know how I want to respond to this. I want to respond to this using the argument that my claims are directed to a practical application. They're not directed to a judicial exception. So I say they are directed to a practical application. And I also had an interview with the patent examiner. And during that interview, the patent examiner told me that when he looks at something, even if he likes it, his supervisor and his QAS, the quality assurance specialist, they are much more likely to allow it to go through if the applicant is able to show that their claims are well within the guidance provided by the patent office, like they're examples of eligible subject matter. And so what you can do is you can find other people who have gotten that same kind of input from the examiner and are applying it in the same context. So in here, I put in practical application, and I'm going to also put of example, because this examiner said that they want to see something or an argument showing that your claims are similar to the examples of eligible subject matter. So again, I'm going to apply the selections. We can see that there are these little snippets that we can use to say whether or not to sort of see where things show up. And we can see in the second result here that it directly talks about the examples. So the first one it's not 100% clear, but I'll just go to the second because that is. And what we're going to do is the same as we did before, except instead of just saying, oh, let's look for electric power group, we're going to see exactly how this person applied the examples using the argument that I want to make in my case. So we'll scroll down to where they talk about the examples from the Patent Office's subject matter eligibility guidance. And we can see the first example is they're talking about example 38 from the eligibility guidance. And let me see if I can find the precise page where that is thrown out on. So yeah, here we are, the eligibility examples, 38. And they talk about this example number 38 is one where it shows that it doesn't recite a mathematical relationship. Therefore, under this example, it was found to be eligible, and they apply that here. So this is something that I can use, but this isn't exactly what I'd been looking for before. However, we know from that snippet that they did make precisely the argument we were looking for. So we're going to scroll down to, here we are, example 40. And this is the one, the mental process in claim 1 of example number 40 was found to be incorporated into a practical application. So by taking advantage of the fact that other people they're drawing from the same well, right? They are drawing from the same guidance, the same examples, the same patent office materials. They're talking to the same examiners, and the examiners are raising the same issues and making the same requests. I can drive efficiency as well as respond more intelligently when I'm putting together my response in my office action where I want to make a particular argument and I want to make it in a particular way that the examiner has indicated they would find to be persuasive. And when I first started working with file wrapper analysis, this is really what I've been thinking. So I would do things before sort of these different software products were available. Like I would go to Pair if there was an inter partes review, and I'd look at other inter partes reviews just to see what there was. And I found that being able to build those efficiencies, building on other people's work to drive efficiency and not reinvent the wheel was really, really valuable. But Julie, I've spoken with her, and she derived ways of using file wrapper analysis not just to drive additional efficiencies, but also to inform her strategies for communicating with patent examiners as well as with her clients in order to get the best results on the cases she's prosecuting. And so what I'm going to do is I am going to pass this back to Julie so that she can talk about some of her strategic approaches when she has used file wrapper analysis to build strategies and to make better kinds of interactions on her patent applications. So, Julie, I believe the floor is yours.
Okay, thanks, William. So recently I reached an impasse with an examiner in a patent application that I was working on that was directed to a personal care composition. That personal care composition could potentially be a game changer for my client in a particular category. And for that reason, the client was eager to obtain patent protection for that composition and wanted to avoid an appeal if at all possible, because that would certainly prolong the pendency of the application. The examiner with whom I was working is Examiner Chicos, who is a former patent attorney. And we had gone through several rounds of office actions in which Examiner Chicos would either maintain prior 103 rejections of the claims without a ton of analysis or of our arguments, or she would simply withdraw the 103 rejections, shuffle the prior art around a little bit, and issue another 103 rejection. So clearly, both myself and the client were getting frustrated, and when we got the latest office action with yet another 103 rejection, I thought that perhaps a different approach to responding to it was warranted. So for that reason, the first thing that I did is I got on to some of the publicly available databases that show examiner metrics. And no surprise, I found out that Examiner Chicos is rated as very difficult. And that's even in comparison to her, to other examiners in her art unit. I also saw that having interviews vastly improved Examiner Chicos's passage rate. But what I couldn't tell is what transpired in those interviews that were persuasive, the arguments that were persuasive to Examiner Chicos. So what I want to do now is kind of recreate the research that I did, not using the office action that was actually at issue, but another an office action from a published application where the fact pattern was pretty similar in that Examiner Chicos had rejected the claims probably 5 or 6 times based off of a 103 argument. So as you can see, I drug and dropped the office action into the software, and now I am going to narrow down the results that I want to review. I go to step 1 and I indicate that I want office actions that address rejections under 103. That's fine as is. Then I go down and select the parameters that I want. I want office actions issued in applications specifically examined by Examiner Chicos. I want office action responses that have resulted in success. And I also want office actions either prior to the response being filed or after the response being filed that specifically refer to interviews or an interview. So I enter that down in this box below, and then I go up and I apply my selections. And I get 3 hits. And as William mentioned before, there are little blurbs where my keyword pops up in these applications. And I can see very quickly that based on these blurbs, there really isn't any substantive discussion of an interview. I can see that Examiner Chicos has simply invited the applicant to call her if they want an interview. So I think of another way of how I could get an argument in front of Examiner Chicos that's maybe outside of the 4 corners of an office action response. And I think, well, what about an inventor's affidavit or declaration? So I go back and I get rid of that interview for my key terms, and then I indicate that I want to look for successful office action responses that were accompanied by an affidavit or declaration. I go back up and I apply these selections, and I see that there are only 2 results. And I look at these and I think, well, maybe this metal soap, maybe the claims are a little bit more similar to my personal care composition. So I decide to take a look at the office action response that refers to the declaration or affidavit. So I will pull that up here, and then I scroll through the office action and I see where the examiner, where the applicant talks about the declaration of the inventor. And I also start to see that the applicant is going back and telling a little bit about the problem that the claimed invention addresses. And I see that the applicant talks about how the inventors have overcome the prior art rejections. And I start to think to myself, well, maybe the invention story is really important to Examiner Chicos. And the way that I can tell that is I can go back to my results, and I can then click on Access Results and Related Documents. And once again, I can take a look at any office action that Examiner Chicos issued after that response was filed. And that would be this right here. Now, in the interests of time, I'm not going to take a look at her final rejection right now, but what I want to show you is this. I can go through and I can also look at this other application to see if that invention story is indeed important to Examiner Chicos. And in the application that I was actually working on, that became readily apparent. I was also able to do the same type of research to see how her SPE would respond to those types of arguments. And as you can see, all I have to do is check this box here and then go back and reapply my selection. And then I get a lot of different results that I can then narrow down by either including certain search strings, or I can ask for an office action that has a particular search string, as I did before when I entered naturally occurring for that 101 rejection that we talked about. And the nice thing about this is using this iterative approach, I was able to build a plan for responding to the latest 103 rejection that Examiner Chicos had issued. And I was able to build a plan that included involving the inventor to tell his invention story via an examiner interview. And I was also able to recommend to the client that, of course, Examiner Chicos' SPE, David Blanchard, should be involved in the interview. But more importantly, I was also able to kind of pick and choose from some of the points that I thought that both examiners felt were super important when telling the invention story. And in that way, I was able to give my inventor some talking points to rely on when we had that interview. And so we did have the interview. We filed an office action response after that, including an inventor's declaration. And for now, we're just waiting to see whether or not we have actually advanced prosecution of that application. And but for this file wrapper analysis, I don't think that I would have been able to as readily make the recommendation that I did to the client. So that being said, I'm going to hand the presentation back over to William.
Excellent. So, yeah, that is a neat story. I have not had that precise issue come up, but I love the way in addition to just getting efficiency, Julie was able to inform her strategy using the history of what other people have done and learning from that. And I think that's actually a really key benefit of file wrapper analysis. And so I want to just kind of close up by extending beyond what we've done so far. So we've talked about efficiency and strategy based on what's worked before. And that makes a lot of sense, right? But you can't just look at what works. You want to also learn from your mistakes, because a wise attorney learns from their mistakes. On the other hand, beyond that, a successful attorney will learn from other people's mistakes. And so that's what I want to talk about right now. I'm going to take a quick break to take a drink of water, and then we're going to look at this office action where I think it illustrates how you can learn from others' mistakes. All right, so what I've done is I have uploaded a office action where it's a 103 and it's based on official notice. And what I want to do is I want to traverse that and see the right ways to make that happen. So we'll proceed. And we can see here various results. So what I'm going to do is just like we've done before, I'm going to say I want official notice, and I want to see official notice. And we're going to look for successful responses, because first I want to see what works. So we're going to say, all right, apply selections, and let's see what our first result looks like. So what we're going to do is we're going to use this as potentially a template for how I can traverse official notice on my case. So we'll scroll down to where they discuss the official notice. And in this case, they said, all right, the office action alleges that this Uccino reference discloses various features, but it doesn't teach this feature of a relative channel length. And they start their argument by pointing out, look, there is no documentary evidence provided for this, so that we're traversing it, because official notice is something that you can ask for documentary evidence. It's supposed to be something that is capable of easy and unquestionable verification, so he's traversing on that basis. Emphasizes, though, there's only a single place where this is actually set down, and that's the applicant's own disclosure. And this applicant, in their successful arguments, then analyzed the prior art to kind of explain, look, you're not just making a little tweak to the prior art with this official notice. This is actually kind of a big change, because due to the nature of these amorphous crystals in the prior art reference, what you're saying would have been well known and obvious under official notice, in fact, isn't even applicable. And as a result, they reiterate the request for documentary evidence, and they specifically tie that to the differences between the prior art and the relevant claim limitations. So great. I now have a template that I can potentially use for when I traverse the official notice in my office action. But I'd also like to see what doesn't work, because if I can compare and contrast, I can hone in on the parts that are the most effective. So I've switched looking from successful to looking for failed responses, and I will apply the selections. And what I'm going to do is I'm going to look at this result, and I'm going to look basically for the same thing. And I'm going to see what was in the successful response that did not get included in the unsuccessful response, that I can make sure to capture that when I'm putting the response together in my office action. So we'll scroll down to where they discuss official notice here. And here we go, claim rejection. All right. So in the office action, it was acknowledged that the prior art failed to teach these various features. All right, great. So same thing. They don't really talk about the documentation. They just say that they respectfully traverse. And then they're falling onto the MPEP. So they're saying, look, there has to be some motivation, reason for a worker to make the necessary change. It's almost as though in traversing this official notice, they're doing like a teaching suggestion motivation argument, instead of, and it doesn't really have the same kind of prior art focus that we saw in the last one. So we scroll down, the rejection fails to identify any motivation or reason for modifying. Again, it's almost like a TSM argument, and it doesn't have the same kind of direct discussion of the prior art yet. Now, here we go. So now we're talking about the above-mentioned features are not a mere rearrangement of parts, but again, it's focusing more on the invention. There really isn't any discussion of the prior art or of the request for documentation, or saying, look, here's what you need to show if you're really going to use official notice to get over or to get our claims relative to your primary reference. And then, as I said, this one, unlike the one that we just looked at, did not succeed in overcoming the rejections. And I think this shows kind of a broader general idea, and it builds on what Julie had talked about with strategy and what we talked about initially with efficiency. Because with patent prosecution, the same issues come up over and over again. And every invention is different, and every examination is different. But there are going to be commonalities. And because we're playing from the same rule book, we can apply those commonalities beyond just our instant cases to use, for example, the strategies that Julie found, or to compare and contrast between successful and unsuccessful responses in order to put together the strongest response we have, or simply just to be as efficient as possible by using already existing successful responses rather than having to reinvent the wheel on a case where maybe we haven't seen it before. And so I think with that, I've laid out where I think file wrapper analysis can really help drive efficient and intelligent patent prosecution. And with that, I will check the question area, and let's see if there are any questions at the moment. There are no questions. So if any of the attendees have any questions, on the right side of your screen, there is a control panel. You can ask questions. If there is anything, feel free. We can address those issues. If not, I very much appreciate your time and hope that you are able to benefit from the work that your compatriots have done and that can be found in file wrappers, and get more efficient and intelligent results for your clients. Thank you so much. Bye-bye.